Bismillah, alhamdulillah, wassalatu wassalamu ala rasulillah. Assalamu alaikum wa rahmatullahi wa barakatuh. So this is the last session on the Waraqaat, inshallah, and we'll just wrap up the final topics. It will be a little bit faster because we've got more to cover. I'll be traveling this coming week, so I wanted to finish this because I'll be away for about 3 weeks, really a month. And if I didn't want to wait a month. And with traveling, it's not easy to set up equipment. And so I thought I'll just get double the amount, hopefully. Hopefully it's not too long. And the last topics are sort of summarized anyway, and they're pretty straightforward. The bulk of it we've covered in terms of the text. So let's get started, inshallah. Just give me a moment. Just go to presenter view. Okay, yeah. I put up a slide there. Just you'll see on the slide that there are some Dr. Mutlaq in his final lesson, or the last hour, 2 hours of his lesson, he puts up a slide. But just I sort of translated it roughly, and parts of it are colored and parts of it are not colored, like the way he did it. But basically, this is talking about evidences that are agreed upon and not agreed upon amongst the mujtahideen. On the left side is the that which is muttafaqun alayh, that which is agreed upon, meaning as sources of Sharia, Quran, the Sunnah, Ijma' and Qiyas, and we'll cover Qiyas shortly, inshallah. In the next slide, we'll start. These are the four that all the jurists, pretty much there's Ijma' on this. In Qiyas, there's a slight disagreement, but in reality, this is mujma' alayh, there's consensus on this, that these are the four agreed upon. There are other evidences, and on the right side, it mentions some of them. Statement of Sahabi, radiallahu anh. We mentioned this earlier. Istishab, which was come later on, inshallah, today. Istihsan, juristic preference. These are in more detailed books. We want Masal Mursala, what is common good, like the community good, well-being. Shara'a min qablina, Sharias before us, like the previous Sharia, like the Yahud and Nasara, like their laws that they're given, are they something that's supposed to be maintained? And or Amal of Ahlul Madina, as an example, right? The according to Imam Malik's mazhab, his fiqh, one of the source of Sharia, the masadir, it's called the masadir al-tashri'. Like, where do we take out the sources that we take our Sharia from, the laws, Islamic laws taken from? So for him, one of the things was the amal of Ahlul Madina, right? Again, Imam Malik, rahmatullah, the time and place that he lives is the amal of Ahlul Madina. And there are many, many hadiths about the virtues of the people of Medina and the city of Medina and the blessings therein. But also that he's so early on, basically he's dealing with tabi'een. So you've got like the children and grandchildren, fuqaha of Sahaba radiallahu anhum, the collective memory, the recent memory of Rasulullah sallallahu alaihi wasallam and Khulafa Rashideen and whatnot. So because that's there, then he's, as an example, this is according to him, but it's not according to the other imams. So it's a mukhtalaf fih, right? Other imams have refuted this as a methodology of source of Sharia. So it's mukhtalafi. So there's disagreements regarding this. What's highlighted is in Imam Juwayni, in his book here, he doesn't cover Quran as a mustaqil, as a chapter in its own right, or the Sunnah. It's not covered. We did a chapter on akhbar, right, regarding narrations, and we only sort of covered two. And didn't go into detail. But in other detailed and larger works, Quran is like its own section or unit, right? It's dealt in a lot of detail in Usul of Fiqh works, and Sunnah is treated in a lot of detail. And so we did some of them we dealt with, but not, when he talked about akhbar. Ijma' was discussed as a separate chapter, qiyas, but what covers the Quran and Sunnah, like what we analyzed in the beginning, was the things when it comes to language, amr, ordinances and nahi, prohibitions. Then we linguistic indications of rulings, like when you're analyzing language, is not covered, but topics of that were covered, like not in the way that detailed books cover, but we did cover Aam and Khas, Mutlaq and Muqayyad, Mujmal and Mubayyan, Nas and Zahir. Also, topic of Nas was mentioned last week, abrogation, things being revealed earlier and then being cancelled out, abrogated later on. Preference, like how a view is preferred. Some things will come later on, orders as well, and contradictions. Apparent contradiction of Zahir, we talked about last week. Right. So I'm just mentioning this to you because just so you have a little bit of an overview, this is a very summarized translation of Dr. Mutlaq's presentation in the Waraqaat course, just so students are aware that like we sort of didn't deal with Quran and Sunnah like in its own right, right? And despite it being the sources, the primary sources of Sharia. Yes, when you go to larger books, but aspects of what we do analyze in when it comes to fiqh purposes, Aam and Khas and all these points were covered, and they did deal with the Quran and Hadith, but not in its own right. All right. Some dalils will not be dealt with, not even mentioned here in this course. There are other dalils, other than this, some have counted up to 10, and people have done PhDs on it. You know, the sources of Sharia that are, for example, fatwa of Sahaba, statements of Sahaba radiallahu anhum, right? So, you know, there's disagreement on that. Is that a source of Sharia even? Like, so there's discussion, you know, these are mukhtalafi, there's difference of opinion in regards to this. So you can say that the sources, the masadir of Sharia are two, that which is agreed upon and that which is disagreed upon. Yeah, so we'll go to the next. We'll start because the time is short and I want to get a lot covered today. So we have about another, inshallah, 10 slides to cover today. So hopefully we can get through, inshallah. Qiyas, the fourth masadir Sharia, source of Sharia is Qiyas. I'll read the slide. There are 2 pages on the slides here. So I'll just cover the first one. As for analogy, it is referring to derived case back to the original case through an effective cause and illah that connects them in the ruling. It is divided into 3 categories: analogy by effective cause, analogy by indication, analogy by similarity. And I'll read from the book, the commentary. An analogical reasoning, that's the way he's translated here, is returning a derived case, a fara', back to the original case, an asl, due to an apparent cause illah that joins them in the ruling. For example, rice being analogous to wheat with regards to interest, as they are linked in that they are both edible, right? Remember that when you exchange things, then the exact amount should be exchanged back, like wheat for wheat, like a kilo of wheat for a kilo of wheat. If there's any discrepancy, then it becomes interest and it's not allowed. And the illah, what's common between rice and wheat, because in some places rice wasn't a common in the time of Rasulullah. If I remember, there's like a narration, Hayat al-Sahaba, where it mentions about when the first time Sahaba encountered it, right? So it wasn't something, and in some countries they have flour as a staple, as a qutul balad, and some have rice. Like in Asia, Southeast Asia, East Asia, it's more rice than is flour. Anyway, because that's an edible or a staple, then that is the common thing that unites them. So what does qiyas mean? Qiyas means to measure, like you're measuring a cloth. Like, for example, they have the metal, like the tailors have or the cloth merchants have, and they measure against something, or a land is measured, right? A shorter definition of qiyas or in usul of fiqh would be connecting an asl to a fara in a hukm, in a ruling that unites them or includes them both together, right? So, for example, someone invents a new alcohol, let's say whiskey, like it's, there's no hadith or ayat for whiskey per se, as far as I know, right? But that the asl is khamar, is wine, the fara is whiskey or bourbon or whatever other hundreds of alcohols have been invented since then, right? Tequila. I mean, we make istighfar and all of these, but they're all haram, right? But as examples of things that, at one point in our life, we never heard about it. And then these things became common from different parts of the world. So the this alcohol now is the fara, and the asal is khamar, right? Made out of grapes or dates, right? The illah that binds them both together, right, is the iskar, which is intoxication. This intoxicates and this also intoxicates. Now there's illah, the underlying the illah, the reasoning that has united these two, right? The hukm of one will extend to the other equally. It's the same thing because the exact same reasoning is found in this one, is found in the other one as well. This is a definition of what qiyas is linguistically. There are many breakdowns of, like there's breakdowns, sorry, I just went to the wrong slide. There's many breakdowns of qiyas, like you can subdivide qiyas in different types of qiyas. Like there's qiyas al-jali and qiyas al-khafi, that in the far'i, the illah, the underlying reason is more obvious, more clear, right? And in a khafi, it's the opposite. There's another breakdown. Like for example, someone is Allah subhanahu wa ta'ala says, do not say uff to your parents, right? Because of the harm that might be the harm that is caused to them. Harm is more prominent in if somebody billah hits their parents, right? Hits their parents, right? So that's more harmful. Hitting is more harmful than saying uff, just a simple statement uff, which is prohibited in Islam. And hitting is more severe, right? Since hitting is more severe, but you can see that the illah, which is the harm, the reason why it's forbidden, is more stronger in the fara than it is in the asal, right? Then there's another breakdown, qiyas, awla, musawi, and then the level of qiyas in each, right? So for example, again, the example of uff is less severe than hitting. This is qiyas awlawi, like it's more prominent. For example, like it's musawi, it's equal. And I gave the example of alcohol earlier. It's exactly like the illah matches exactly in the fara and the asl. Or for example, like Allah subhanahu wa ta'ala said, do not eat, right? Consume the wealth of a yatim. What's the illah? Like, why is it forbidden not to destroy or ruin or finish or destroy the wealth of an orphan, right? Consuming, when you consume the wealth, meaning you spend the wealth of an orphan, you take the wealth and you use it for yourself. So what's actually happened is that you've used up their wealth, right? So if a person was all the ways that the wealth can be destroyed, right, they would fall under the category, right? Akal means like literally consuming or spending it for yourself, or in any shape or form that you do the thing. So it's all equal, right? Because the underlying illah for forbidding is that usurping the wealth of the orphan, right? So they would apply to all those cases. The end effect of all those situations, different situations, the orphan's wealth is misused or harmed. All of them will result in the same thing, which is that the orphan will lose their wealth. Or a lower amount, lower. So, for example, that the illah in the asl is more clearer than it is in the fara. For example, nabidh. Nabidh is putting dates in water, leaving it for several days. So, khamar is a clear cut. A wine is clear cut, muskir. It's an intoxication. While nabidh is not so clear cut, right? It could be intoxicating when you leave it for a long time, or it might not be. Initially, it might not be, right? So the illah is not so clear cut in nabidh. And there's a big debate regarding nabidh. Is it really intoxicating or not? There's a whole discussion around that and ikhtilaf on that. There's another breakdown of breakdown of within qiyas, types of qiyas. A type of qiyas that matches with the qiyas, or I'm trying to think of it's called aksi. aksi is like the opposite. So an opposite hukm is derived via qiyas, right? So Allah subhanahu wa ta'ala has forbidden saying uff to the parents. Then the opposite by analogy is derived, which is that to say nice words is permissible or mustahab, right? So for example, alcohol is forbidden because of being intoxicating. Drinking juice will be mubah, permissible. A reverse hukm via analogy is derived. So then there are three, the book classifies three types of illah. This is like you could say the fourth breakdown. Fourth breakdown. So, and the first one is, I'll read from the slide. Analogy by effective cause contains an effective cause that necessitates a ruling, right? And he explains it as causative analogy, qiyas al-illah. It's called qiyas al-illah, that in which the apparent cause necessarily requires the ruling whereby it does not seem sound rationally for it to deviate from. For example, beating being analogous to saying fi or uff to one's parents with respect to it being unlawful because of the apparent cause of harm, right? The illah is very obvious. In both cases is harm, right? That harm is going to cause to the parents, right? Hitting is harmful. And so this illah is very clear cut. It requires very little explanation. The harm, which is the illah, is very obvious in the second, in the farah, right? So this is called causative analogy, right? The second is called indicative analogy and qiyas al-dalala, right? Analogy by indication is inferred by one of the two identical cases from the other. It is that the effective cause indicates a ruling but does not necessitate the ruling, right? So there's an indication of what it means is there's an indication of the illah, but not the illah. There's indication dalala of the illah, but not the illah itself, right? So you're making qiyas based on a sign of the illah, not directly the illah. In the first case, the example given of harm is obvious, right? The illah is harm, and that is obvious in the asl and the farah. In qiyas al-dalala, there is an indication. For example, the smell of alcohol, right? There's some food or drink and you can smell the alcohol in it. Now, we know that alcohol is forbidden because of intoxication. Now, here you don't know for sure, but the smell of alcohol is known. Then the assumption there is, you can see that analogy is being used. No, this is haram because this is very highly likely. And the qiyas is made what? It smells like alcohol. So the presence of, it is a sign of the presence of the illah, although you don't know, right? So we have enough information that, for example, as an example, a modern alcohol that is from Central South America, I think from Mexico, tequila. It's a modern alcohol, as far as I know. And this modern alcohol is made in a total different way from grapes. But we have enough information to know that it works exactly like wine. The exact same process involved, in slightly different, but it ends up in a drink that is intoxicating. That is why people drink it. It's well known. It perfectly resembles, matches with wine, as in the time of Rasulullah Sallallahu Alaihi Wasallam. The illah is very self-evident. But let's say there's another type of food or a drink that is unknown, but it smells when you bring it to your nose, and it's got, and you never had. We're in one country, an island in Pacific in Australia. They had an alcohol called Kwazu. Kwazu is the name of the alcohol. Never heard of it before. Right? But if you bring it in front of you and you smell it on somebody, it smells like alcohol that we all know. So the smell of it tells you that this most likely is alcohol. It most likely has iskar, intoxication. Hence, the hukm of it would be the extent of the khamr would extend to this as well. Although the qiyas is dalala, not illah, because you don't know for sure. You're assuming that these signs that are there, these dalalas is the indications that are there, they make it haram. The third one, and I'll read from the book as well, that indicative analogy is using one of the two identical things as evidence for the other. It is when the apparent cause illah indicates the ruling without necessarily requiring the ruling. For example, a youth's property is analogous to a mature person's property in it being obligatory to pay zakat from it because they're joined in being susceptible to growth. It is possible to say that zakat is not obligatory with respect to a youth's property, just Imam Hanifa rahimullah said concerning it. So according to Imam Hanifa rahimullah, there's no zakat on a child's wealth. Let's say there's an orphan or or a child that owns property, there's no zakat on them. They're not mukallaf for zakat. They're not legally obligated to do zakat. While according to Imam Shafi rahmatullah, Imam Ahmad, zakat has to be given on a child zakat on their wealth. So there's the analogy being made of a youth's property is analogous to a mature person's, right? And there'll be a counter argument to this from the other side why it's not, right? The third qiyas shabah, analogy by similarity, is derived case related to two original cases. It is not resorted to if the previous types of analogy are possible, right? So you only use qiyas shabah, which is a third type, only when the first two are not possible, right? Analogy of similitude, qiyas al-shabah, is when the derived cases resemble two source cases, so it is attached to whichever one is most resembles. For example, recompense for a damaged slave. There's a better example. I mean, I can read through it. I'll just read it because it's there in the book. Since with respect to the recompense, there is an indecision as to whether he is analogous to a free human from the perspective that he's a human, or an animal from the perspective that he's property. He resembles property, from then he resembles a free human, though the proof that he's sold can be inherited or declared an endowment, and there is a recompense for his components when damaged in proportion to when damage reduced from his sale value when complete. And we might read this and see, like, what a way to talk about human beings. But even if you go to court today, and in Australia, compensation courts, and where claims are made, probably in any Western country that you're in, where you go for injuries and liability, like in a factory, you get injured, you hurt your back and so forth. I mean, they talk in these terms about employees or wage earners, workers as well. But anyway, qiyas al-shabah is the most weakest form. It's attached to two cases. So, for example, sleeping, when a person sleeps and misses their salat, sleeps in, then they have to do qada. This is case one. Case two is there's agreement on that. The qada has to be done if he's missed his prayer, if he slept in. So whenever he wakes up, he makes his missed prayer. The second, it's also agreed that a majnoon, another person whose mind is, you could say, switched off, doesn't have to do, there's no qada on them, right? Now there's a third case. Now we've got two cases there, right? A sleeping person, and a majnoon person. You have now a third case of a person who's fainted, right? Mughma alayh, the fainted person, right? Behosh, someone has lost their consciousness, right? They fainted. So now, which one should we make qiyas for the fainted person upon, right? Should it be on the sleeping person, or should it be on the majnoon? Anybody know? We did it last when you did the previous book. No one? Okay, no one. I'm giving you a chance, last chance. Okay. So for the Hanbalis, it will be according to the sleeping person, right? The fainted person is treated like, so he'll have to make qada, right? Even if it's for a long time, he's fainted. And for the others have the view, no, he's like a majnoon person, like the pen is lifted for him in that situation. Others said, no, there actually is a reference to Ammar bin Yasir, radiallahu anhu, qada, and his statement, and the qawl al-sahabi is a hujjah, is a proof, and there's no objection to that, right? So before we get into the conditions, and I'll read, I just read that actually, sorry, the Shabah. Now we talk about the conditions that are integral to analogical reasoning. Some conditions to mention regarding qiyas, the pillars or the arkan of qiyas. You have to have an asl, right? You have to have the illah, right? And you have to have the fara', the derived masala, the new masala, and finally you have to have a hukm of that, which extends from the asl to the fara' via the illah, because they share the illah the same. The hukm extends out and includes the fara' as well, and shares it via the illah, that hukm. and there are conditions for these. So firstly, in the slides, it mentions there, among the condition of derived cases that it be suitable to the original case. Among the condition, the original case is that it is established by evidence and agreed upon by conflicting parties. So, and here it mentioned a condition derived case is that is appropriate to the original case. This is with respect to what links the two together for the ruling, meaning that something joins between them that is appropriate for the ruling. So, for example, you can't say like apple juice is haram because it looks like beer, right? Like apple juice, if you pour it and it gets a froth on top, it looks exactly like beer. So you cannot say that apple juice is haram because the color of apple juice is the same as beer. That is not appropriate. So the illah that is between them, so they can share the hukm for fiqh purposes, has to be it has to be appropriate, right? And this process is called masalik illah, isolating the illah, exactly why one hukm can extend to another situation. This is a very, and someone who doesn't know these things, these intricacies, and be able to understand this, is not allowed fatwa if he doesn't understand. He's not allowed to issue fatwas if he doesn't understand this. I mean, this is the least thing, because you require precision, because you are speaking on behalf of Allah subhanahu wa ta'ala. It requires precision. And there are examples from the sunnah where it goes in reverse, like araya is a type of trade to do with dates, that where dry dates can be sold for, and there's a discrepancy between dry dates and fresh dates on trees, right? There's a estimate being done there. Under normal circumstances, the rules of exchanging dates and dates that are on trees and dates that are dry will not be allowed, but there's an exemption made for ease by Rasulullah sallallahu alaihi wasallam. Or forward selling, like someone will say, well, you can extend, since a pregnant animal is not allowed to be sold, like what is in the womb of the animal is not allowed to be sold, then a salam trade is a type of trade. No, Rasulullah sallallahu alaihi wasallam, it's perfectly fine. That trade, salam or salaf, there's two names for it. Both of these trades are, it's the same trade. It's perfectly permissible in Sharia. But a person might do their own qiyas, and based on other things, might say, no, this is not allowed. But Rasulullah sallallahu alaihi wasallam, in front of nas, there is no qiyas. And remember always this, in front of nas, in front of explicit text, there is no qiyas, right? So the first condition is there's a munas, the illah, the illah is between the asl and fara is appropriate. The second condition is on the slide, among the condition of the effective cause is that it be continuous in its effects, such does not alter its wording or meaning, right? Right. So, and here I mentioned the condition in the original case that is established through evidence that is agreed upon by the debating parties, so that the analogy is binding over the debating party. If there is no debating party, then the condition of that, the ruling of the original case be established by evidence that the one making the analogy himself consider authoritative. So this is talking, there's a sub-science which sort of extends out, but it is a separate science called the ilm jadal, which is there's a whole science, sub-science of disputation, how debates are done. And so this is what it talks, when he mentions two disputing parties, that's debating parties, they're arguing about a point, a fiqh term, and they've got opposite views. So that and so the terms of basically that the qiyas is established via a dalil, like you got to establish it from the Quran or the Sunnah or ijma'. You cannot establish qiyas just from qiyas itself. You got to establish in firmly grounded sources that it will when the qiyas is done, then if there's a conflicted party, somebody that is objecting, that your argument is so solid that they have to accept, okay, that this does extend out to it. The condition of the and then we'll continue the condition. Among the condition, the effective cause that it continues in its effects. Among the condition of the rulings that it's similar to the effective cause in negation or affirmation that in its existence or non-existence, if the effective cause is found, the ruling is found, and the effective cause is what results in the ruling. So I'll just read it from the book here. It's quite long. Condition of the apparent cause is that the constant in the rulings, so that was a previous one that I read before, where it exists and that is not inconsistent in phrase or meaning. The analogy is invalid whenever the apparent cause is, number one, inconsistent in phrase by its holding true for the characteristics which are in indication of the apparent cause, illah, in one scenario but not the ruling, or inconsistent in meaning by the meaning of the apparent cause, illah, existing one scenario but not its ruling. So this is when an argument is being done, like let's say a debate is being done, then the whole point of debate is to break the other person's qiyas, right? Dr. Mutlaq gave the example of people doing, like, for example, qiyas, and they trying to come up with an illah, their own illah. So, for example, we know that zakat is there on sheep, / goats, camels, cows, etc. And there's a certain way to give zakat. You can't just give 2.5% zakat because you'll have to come up with 2.5% of a goat. So you do zakat on, like, for every 40, there's one sheep, that sort of thing, right? For every 40 goats, there's one goat. So somebody could say, well, the illah of zakat is to help benefit the poor. Then you can extend this out to chickens, right? Because you can enrich the poor with chickens. So if you have 40 chickens, right? But then the problem is that when you extend this out, the inconsistencies start to show in this, because, all right, then, like, you should give 2.5% of your house or 1/40th of your house, right? You have to give such and such of your everything. That applies to your clothes on your back, every type of property that's owned. So the qiyas starts, in jadal, in that science of disputation, you're trying to break your interlocutors, like your opponents' qiyas. You're trying to break their qiyas, their analogy. And you can see the modernists, they have this problem. Their qiyas start to fall apart very quickly. The madahib, they are solid, like, and their qiyas has been, like, rigorously tested and so forth for more than a millennium, more than 1,000 years. So these new qiyasas, the modernist qiyasas that are coming up, they start to fall to the side. They don't last very long, actually, and the inconsistencies start to appear, and they don't hold their, they cannot hold their ground. So I'll just continue reading the commentary. The first, inconsistent in phrase, like saying that killing using a blunt instrument is premeditated murder. قتل عمدا so reciprocal retaliation, qisas, obligatory, just like killing with a sharp instrument. This is rendered inconsistent by the scenario where father kills his son, since it does not obligate reciprocal retaliation. The second, inconsistent in meaning, is like saying the zakat is obligatory for livestock in order to alleviate the needs of the poor. This is rendered inconsistent by the same apparent cause illah, alleviating needs of the poor via zakat, existing jewels, while there is no zakat for them. So there's limitations for zakat. Another thing that where there's no zakat is in that which is abrogated, that which is mansukh, right? Sorry, astaghfirullah azim. If there's something is mansukh, right? He put some conditions. I'm just reading from my notes. So when it comes to there's no, like, when a ruling is mansukh, like abrogated, then there's already that's cancelled out, and what comes after it is muhkam. And in that there is you cannot use a mansukh, something that's abrogated previously, and make an qiyas from the whatever was in there, the illah that was in there, because that's already, that is mansukh, and the illah is also mansukh. Also, if something is ta'abbudi, right, it's revealed and then no logical reason is given for why it is. So, for example, in the Hanbali mazhab, camel meat breaks your wudu, right? camel meat breaks your wudu, or there's no qiyas you can do on that. Like you can't say this extends to lamb or some other things. Or for example, the zuhr is 4 rakats. There is there's definitely a hikmah in it. There's definitely a reason, but nobody knows. Only Allah knows, right? Or tawaf is 7 rounds of the Kaaba. One tawaf is going around the Kaaba 7 times, right? Sab'a ashwat, 7 shawts around the Kaaba. This is ta'abbudi, and we cannot make a qiyas analogy on that. All right, let's continue. I'll just finish reading here. A condition of the rule in hukm is that it's similar to the apparent cause illah with regard to absence and presence. Following the apparent cause in this, when the apparent cause is present, the ruling is present. When the apparent cause is absent, the ruling is absent. The apparent cause illah is that what attracts the ruling due to the apparent cause being appropriate for the ruling. And the ruling is that which is attracted by the apparent cause because of what was mentioned. The next section is called al-hadar wal-ibaha, prohibition and permissibility, right? As for forbidden and permissible among people are those who say that things are forbidden except if the law permits them. If no indication is found in the law to permit them, the default position is adhered to, which is that it is forbidden. So as for the impermissibility and permissibility, some scholars say that things after the Prophet ﷺ was appointed to spread Islam are impermissible. That is upon an attribute which is being impermissible, unless the legislation declares it permissible. And so if nothing in the legislation is found that indicates permissibility, one adheres to the original state's impermissibility. Everything's haram till it's made halal, right? So after Rasulullah, that which is made halal for us has all been made halal for us. Other than that, it's all haram, right? Some scholars hold the opposite, that the default state for things after the Prophet ﷺ was appointed is the opposite, permissibility, because bididdi is the opposite, except for that the legislation is declared impermissible. So everything is halal except that which the Sharia declares haram, right? And then the sound opinion is that it is contextual. Harmful things are unlawful, beneficial things are unlawful. As for before the Prophet ﷺ was appointed, no bi'atha, no ruling is associated with anyone because of the absence of the messenger to bring the ruling. So let's go through this. This is related to the topic, the next section, istishab, right? It's one of the, in the list at the beginning of the dalils, source of Sharia in which there's disagreement. So it's called istishab, right? The presumption of continuity, right? And this is something there's disagreement. Is everything halal or is everything haram until it's made haram or halal, respectively? Like so certain things Sharia is quiet on the matter. So before Sharia has anything to say in it, what's a hukm, right? This doesn't apply to, obviously, people cannot say, let's say if the position is taken that something is permissible till proven haram, right? Then like shirk, for example, right? A person said, well, this idol is halal, na'uzubillah, this idol is, I'm allowed to worship it because everything is permissible until it's proven otherwise, right? Or for example, something is harmful, like eating burning coal, right? And that last point there, what it mentioned, and I'll read it off the slide again as well. Or some scholars say that the asal, the original state of things, is that it's permissible in all beneficial things. In all beneficial things, the normal state, the status quo, the default mode is permissibility, right? As for ibadah, so this is maybe you can put it into foods and financial things, and also these are all halal until proven the haram. And ibadah is the reverse. It's haram until you come with a dalil that permits it, right? And of course, after Rasulullah ﷺ, the idea of ibadah, so there are arguments, there's big discussion around this. It's not about when the imams are putting these conditions, or that it's haram till it's haram till it's halal and halal till it's haram. They're not doing this just like there's one group of alims that are like, they want to make things easy for people, and another group that just wants to make things hard for people. It's not about that. It's they're putting concrete rules down that are based on the Quran and Sunnah to get to the truth. The imams, Aim al-Mujtahideen, they work day and night in the search for haqq, and in the work of haqq. This is very important to understand, that we don't project our desires and our lowly selves onto these imams and our misguided and mistakes to them. So Allah subhanahu wa ta'ala says, so in the discussions of this, قُلْ مَنْ حَرَّمَ زِينَةَ اللَّهِ الَّتِي أَخْرَجَ لِعِبَادِهِ وَالطَّيِّبَاتِ مِنَ الرِّزْقِ. You can see this is one of the arguments present. Who are the people that have forbidden the beautifications of Allah that Allah has taken out for the slaves and the good things from the rizq, like foods and so forth? Who's the one who makes these things haram? And Allah subhanahu wa ta'ala said, هُوَ الَّذِي خَلَقَ لَكُم مَّا فِي الْأَرْضِ جَمِيعًا. That He is the one that created for you what is all that is in the earth. And there's a hadith that Rasulullah Sa'ad ibn Waqas radiallahu anhu narrated in Bukhari Muslim hadith, إِنَّ أَعْدَ الْمُسْلِمِينَ جُرْمًا مَنْ سَأَلَ عَنْ شَيْءٍ لَمْ يُحَرَّمْ muharrima min ajli mas'alati. Sa'ad ibn Waqas reported that Rasulullah ﷺ said, the Muslim who offends most against the Muslims, like jurm against the Muslim, who offends most against a Muslim is he who inquires about something which has not been forbidden to men, and it is declared forbidden because of this inquiry. There's a hadith in Tirmidhi, Darqutni, that Allah has made certain things binding, so do not cause them to be lost. He has prohibited certain things, so do not violate them. He has fixed certain limits, so do not transgress them. And He, without being forgetful, has said nothing about certain things. This is the point of mentioning this here, that He, without being forgetful, right, without nisyan, has said certain things, has said nothing, about certain things, so do not search into them, right? So Imam Tufi rahimahullah al-Hanbali said that the asl in things, the default mode is asl fi ashya ibaha, is permissibility, right? Imam Juwayni rahimahullah also mentioned a third category of ulama who have a view that they maintain neutrality in this, they make tawaqquf, right? But basically Imam Juwayni argues in his more extensive work, Burhan, and Abu Ya'la al-Hanbali, Imam Abu Ya'la al-Qadi, Abu Ya'la al-Hanbali rahimahullah, says the same thing, which is that it is, this is in the net result of having a neutral position is you're basically have the same, you have arrived at the same place, right? Yeah, so within the Hanbalis, like the Shafi'is and others, imams follow they fall into both camps in terms of the way they look at this issue. The next section is extends out from this. So the presumption of continuity. The meaning of presumption is istishab, right? This is one of the, as I mentioned at the start, which is binding in that default position. Al-asl is taken in the absence of legal evidence, right? And I'll read the explanation here. The meaning of presumption continue is istishabul hal, that is cited as binding, as will come, is that the original state, that is a default of ruling's absence, is presumed to be continue in the absence of legal evidence by the mujtahid not finding any after intensively searching for it, right? As much as able. It is like the mujtahid not finding evidence indicating that fasting in the month of Rajab is obligatory. So he says that it is not obligatory out of presuming continuity, that is a default of ruling's absence. It is binding with sincerity. This is a hujjah, right? It's a binding proof. And then it says, as for the presumption of continuity, that is well known, which is asserting something at a later time, because of its asserting at a previous time, it is binding in our opinion, but not according to the Hanafi. Thus, in our opinion, there is no zakat owed on 20 defective dinars. Defective dinars, because remember the zakat is on 20 mithqal, is a certain weight of gold, whether they've been dinar form or but because they've been circulating so much that they've worn out. So you actually don't have, imagine somebody just had 20 coins, gold coins. 20 mithqal is an nisab of zakat, right? 20 dinars is 20 mithqal. So each gold coin has one mithqal in it, supposed to have that weight in, right? So you have a gold weight, but also has a gold coin as well. But then they get worn out, broken, chipped, and so forth. So if somebody only had 20 gold coins, right? So the madhab goes by the original ruling that it's 20 mithqal of gold. So if there's a deficiency there, then there's no zakat being owed. If that all the person had, and it's less than 20 mithqal, then doesn't apply. While the Hanafis say, no, its value is still treated like that. There is a zakat on that. So you can see that how the ruling presumption continually applies within a ruling, and how the imams differ from each other in that. The priority of evidences. As for the evidences, a precedence is given to the obvious over the obscure. Now we're talking about the order of the dalils, right? So we've sort of finished with the main discussion Imam Juwayni wants to touch on. It's an amazing book, how he actually engages you and introduces you to and gets you deep into the usul of fiqh. Despite the smallness of this book, despite of the, I mean, there are 10 volume books of usul of fiqh. But it's amazing how he sort of, in a very easy way, and you can feel the barakah in this book of a great imam 1,000 years ago writing this, that how deeply he gets you into the topics and discussions. Like he really, we say jumpstart when you put the wires on the battery, like on the car battery to jumpstart the car. He really jumpstarts you in usul of fiqh through this very compact and small work. May Allah subhanahu wa ta'ala have mercy on him. Rahmullah ta'ala. All right. Tartib adilla. Manifest evidence is given. Sorry, I'm just reading from the slide first. As for evidence, precedence is given to the obvious over the obscure, to certain knowledge over certain suspicious, to transmission of analogy, and to obvious analogy over obscure analogy. If a statement is found which changes the default position, the statement is acted upon. Otherwise, continuity is presumed. Manifest evidence is given precedence. So that which is a jali is given preference over the khafi, that is evident and interpreted. So the phrase literal meaning is given precedent over its figurative meaning, right? It's majazi meaning. Like if the obvious meaning is there, you do not sideline the obvious meaning. You give preference to the obvious meaning over any figurative meaning, right? The next one, evidence that necessarily leads to sure knowledge, ilm, all right, is given precedent over that which leads to probable knowledge, dhan. That which is qat'i or that which is yaqini is given preference to that which is speculative or probable. That is like mass transmitted reports and solitary transmitted reports. So the hadiths that are mutawatir, and we learned about mutawatir last week, mutawatir are given preference to, because this is more qat'i. This is much more stronger than give a solitary hadith. A solitary hadith can be sahih, but in front of mutawatir or an ayat of Quran, as some imams, they will not take a ahad hadith over ayat of Quran, over, and never take it as a proof, where the apparent of the Quran, they will practice that as opposed to practicing ahad hadith. So the first is given preference unless it is universally applicable, in which case it is rendered particular by the second, just as what preceded the Quran being rendered particular. So this comes back to the discussion of aam and khas, right? So what you do is the Quran's aam, takhsis is made, or vice versa. And we went through the discussion of how takhsis is made, how an aam and a khas work together when they come together, right? So it's not one or the other. They are combined in a meaningful way. Tatbiq is done, and maybe takhsis is done, specification is done, using one with the other. Something stated. Stated means from the Quran and Sunnah, right? فَإِذَا وَجَدَ فِي النُّطْقِ Nutq is that which is uttered, right, in Arabic. But this is referring to the Quran and Sunnah, is given a preference over an analogical reason, qiyas. That is, unless what is stated categorically is of universal applicability, then is rendered particular by analogy as is preceded. Qiyas, takhsis can be done with qiyas if it is established that this is something that is aam, right? What is said in the text is aam, qiyas can be done takhsis can be done via qiyas. Manifest analogy, qiyas jali, right? Qiyas jali is given preference over concealed analogical reason, qiyas qavi. Similar, a causative analogy, qiyas illa, takes precedent over an analogy of similar qiyas al-shabah. Remember, shabah is the weakest type. If there's a qiyas illa can be done, the stronger type, more obvious, more clear cut that this is the qiyas, then that is given preference. Like if you have a choice between the two, you'll go with the obvious, the qiyas that is jali, is obvious, is manifest. If something from the Quran or Sunnah that is stated categorically is found to change the default state. The default of absence, which when presumed to continue, is expressed as presumption of continuity, istishab al-hal, which we just did in the previous section. It is clear that the categorical stated phrases are used. Otherwise, if it is not found, the original state is presumed to continue, istishab al-hal, that is its default of absence, and it is acted in accordance to it. Right? Unless something in the Quran, some nas comes, then you are obliged to, for example, like alcohol is forbidden. Previous to the hukm, alcohol was drunk. And examples are there from the seerah that Sahaba radiallahu anhu, because it wasn't haram. It wasn't haram not to consume alcohol. There are many Sahaba that didn't consume it their whole life, even before Islam, but it was just part of the normal drink in the society. And there's many examples of that. If that hukm didn't come, then the original hukm would just remain, which is that it's allowed. But a hukm came and forbids it. It's haram till the day of judgment, right? So that hukm changed everything, right? Let's continue to the next slide. Among the conditions of the legal experts are that he's knowledgeable in jurisprudence, its roots, its branches, its disagreements, and its doctrines, that he's completely aware of the indications of independent legal reasoning, recognizing which is needed to derive rulings, the exegesis of verses related to the rulings, and the reports related to them. So we did two definitions already. Sorry, we did two parts of Usul al-Fiqh already. First is the definitions at the start. Then we went through in the last 7 weeks, 6 weeks, we went through the, the steps, the procedures, like what's involved in Usul al-Fiqh, the work, the howness of it, like what is being done, the kayfiyah. And then finally now is the person involved in it, the person involved in it, the people involved in ijtihad, involved in Usul al-Fiqh. What are the conditions? So among the condition of a legal expert, what's in Arabic? Mufti. What's a mufti? That he's knowledgeable in jurisprudence, right? It's asl and it's fara. It's roots and its branches. It's khilaf and it's madhab, right? And so in the commentary here, so that, just to remember these words, not every mufti is a mujtahid, right? And a mufti is someone who answers with dalil, and some say not even with a dalil. A mufti is not required to do that, according to some. But every mujtahid is a dalil, but not vice versa, right? And for a mufti, there are 5 conditions that he's a Muslim. Ijtihad can never be accepted from a kafir. No matter how many PhDs he does on Islam, it will never be accepted. Number 2, taklif. The mufti, the fatwa is not accepted from a majnoon, someone's not of sound mind, or a sabi or an immature child. Despite them having the ability to memorize, despite having a vast knowledge, there are many things that are not acquired just by memorization. It's about there's a development of the brain and maturity that comes, and also experience of the situational, different situations, and to be able to picture masail, right? And to be able to then understand the ins and outs of, and that can only come through an extended period of time, which we'll mention in a moment. The third quality is adala, uprightness, that the mufti is upright, right? In the majority of his ahwal, situations, in aghlab ahwali, that he's upright, right? That he avoids major sins. He's not addicted to minor sins, right? And he avoids those things that are not befitting an alim of sound and noble character, right? In his behavior and his character. So Khatib Baghdadi rahmatullah wrote a book, Faqih wa Mutafaqih, and he said that the fatwa of a fasiq is unacceptable. Fasiq is someone who does major sins, doesn't make tawbah, or does minor sins, addicted to it, right? So there is a standard of what is, and the Arabs say, ulama rabbaniyun, God-fearing ulama, right? We say in our part of the world, we say parezgar alim, a cautious alim or alim of taqwa, right? how do you know that someone has taqwa? He's doesn't do any, we'll mention kaba'ir and sagha'ir, and he doesn't, so he doesn't do major sins or minor sins. He upholds the sunnah and the sharia, put it that way, in simple terms, that in his life. And he's a person that you have to observe quickly, or closely, sorry, not quickly, closely, that is this a person that is scared of consequences in akhirah, right? From the way they conduct themselves and live, is this person fearful of Allah subhanahu wa ta'ala, right? So that's a mufti, like that. If in terms of if he's a alim and he's got this, then and he's a mufti, then these are the things should be looked at very carefully. His knowledge is reliable. He's a musnad al-alim, number one. Number two is that look in him whether he has this fear of Allah subhanahu wa ta'ala, and that you can try to, of course, what is in the heart, only Allah subhanahu wa ta'ala knows. And what is the condition of the person, their judgment, how a person will be rewarded, we don't know. That's in the ghaib. But there are signs to just be careful. And we do this in dunya, right? When we want to do business deal with somebody, we check things out. We want to invest in a company. We want to buy something. We check it out 10 times, 100 times, and make sure that if I'm going to put my eggs into this basket, if I'm going to put, if I'm going to be doing this, then I better be cautious in who I select. And this is a matter of deen, so we should be extra careful. Number four is that he is a faqihun nafs, that he has a innate internal, he's developed after long years of study and research, a malaka, a ability of faqahat inside of him. It's become part and parcel of him. So this is not someone who does like waraqat with wise, or one or two, or goes to just simply a madrasa, or graduates at a madrasa, or graduates at Islamic university. No, this is a lifelong, a person swims in this day and night for a very extended period of time. And this ability, yes, some can get it when they're younger, but generally there's a maturity in the person. The fifth one is that a person has ilm. And this is what the book is talking about, and we'll go through this. So the conditions of a mufti who is a mujtahid include being knowledgeable in fiqh, its foundation branches into difference of opinion in schools. This includes being knowledgeable in legal issues, its foundation rules and its branches. It includes being knowledgeable in the difference of opinion therein, so that he takes one of these opinions, does not go against it by inventing a different opinion. This is due to him being required to conform to his predecessors, since the absence of taking that opinion negates it as a possibility. So this person has to know what the previous opinions are, because he has to work within them. And there's a book by Risala, a small booklet. Sheikh Musa Ferber has also translated. I would recommend that you get that booklet as well. It looks very similar to this. It's I have it here somewhere on my shelf. It's in English. It's a Risala on الرد على من اتبع غير أربع, refutation of those who follow other than the four, right? The refutation of those who follow other than the four madhabs, right? So this is the name of the book, Rad or Risala, a small booklet has been translated, that anybody comes with a view outside the four is to be rejected, right? The Ummahs agree that the practice of Islam are in these four madhab, that's it. And we're not going and say, these are the structures that will work. These are the four frameworks the Ummah has accepted and refined and so forth. And it covers all the Quran and Sunnah. We need not go anywhere else, invent a new Usul of Fiqh and so forth, as some people are trying in the current age. So why does he have to know the khilaf as well? The khilaf also, and what is the madhab, he has to know. Why does he have to know the khilaf? Because some matters are of ijma', consensus, as we've learned. If there is ijma' on it, he cannot go against ijma'. So he better be aware of all the ikhtilafat. And he has to walk the well-trodden path. Many muftis today, they are just naqilin. They are naqil. That's not a criticism. That's just their reality. That they are not exercising an independent view in the madhab. All they're doing is they're mentioning, they're transmitting the view within a madhab, right? So even they're very skilled. While a person that has some level of ijtihad, and the Imam Ibn Rajab in the Risala gives a description, Imam Ahmad Hanbali rahimahullah, that he was a person that was imam in every field, imam in language, and he mentions here as well. He's an imam in nahu, imam in sarf, grammatical sciences, imam in hadith, imam in tafsir, imam in taqwa. right? So someone who decides, and the next one is that being versed in the tools necessary of ijtihad by knowing that is needed to deduce rulings, including Arabic grammar and lexicography, that he knows nahu, lugha, language, the words, the meaning of words, being versed in narrators of reports, the rawis, this is so that he takes from the accounts of those who accepted, not from those discredited, being versed in the commentaries of Quranic verses and prophetic hadith concerning rulings. This is so that he agrees with them in his ijtihad, and not to, he has to know the hadith about that specific bab, like tayammum, for example, or wudu. If he doesn't know all the hadith of that, he might contradict the hadith in his ijtihad, right? He has to know the narrators of number 3 was narrators. There's a whole science, sub-science, asma'ur rijal, right? In hadith science of the chain to narrate and who's who. All right. What he mentioned after being versed in the tools is part of the mass of evidence used for ijtihad. He has the tools, being versed in the tools, right? He knows qiyas, he knows ijma', he knows each thing that is used, he knows the language, he knows all aspects of usul al-fiqh. And he knows a condition for the mufti is that he knows the fundamentals of jurisprudence, right? And other things, specific issues where consensus has occurred and specific issues where scholars disagree and the range of their disagreements, right? So there's only two people that come for fatwa. One is the one that is ahl for it, right? In this time, we have a disaster. We have YouTubers, TikTokers who are just answering questions and like they're not qualified. There are qualified scholars out there who do answer people's questions. One is a person who's trained and he's ahl for that. Secondly, is a person who's an idiot. Ahmaq in Arabic, Dr. Mutlaq called it ahmaq. It doesn't mean that scholars are not allowed to do research, tahqiq and ijtihad. That continuously goes on. That's always gone. It's never stopped, right? It's just that we have less capable people to the level that was there in the past, but it still continues. So, for example, when I asked, and I think I mentioned this before, when I asked Dr. Mutlaq's teacher, Shah in Kuwait, I met him. So I asked him one of the questions about people who say Quran and Sunnah only, number one. He said, Quran, because all of these things, these tools of ijtihad that we're talking about, right, including ijma' and qiyas, they extend out of the Quran and hadith. Quran and Sunnah are the primary sources from which all these other proofs extend. They're an extension. They are tools that are derived from the Quran and Sunnah itself, right? And so I asked, so he said that though they have 2 dalils, while we have 11 dalils or 10 dalils or 11 dalils, 11 proofs, right? 11 sources of Sharia, right? And these 11 are sourced in the Quran and Sunnah itself. So, and that gives you a very sophisticated system to follow Quran, Sunnah and apply to all new cases, right? And the people who say Quran, Sunnah only, it's correct. Nobody disagrees with that, right? But the problem is that when you get to a difficult situation and you don't have a usul al-fiqh, as we have been just sort of in brief in the last 7-8 weeks we're discussing, what happens is then when you get stuck, then when somebody says, show me in the Quran hadith where buffalo is halal. I mean, I'm giving an example. You ask one of these people, where in the Quran you're drinking buffalo milk and you're eating drinking buffalo milk and eating buffalo meat, right? Where is in the Quran hadith? Of course, we know that's not that and a million other examples that are in our life today. But we know that when you ask the fuqaha through usul al-fiqh and through new situation, through these madahib, they give us solutions based on the Quran and hadith in a coherent, through a coherent framework that can be applied to any situation till the day of judgment, right? When I asked when Shah asked him the other thing, for average person, historically, their imam, their madhab was their local imam of the masjid, who was an alim, usually. Unfortunately, this time, many imams are not alims, they're not trained as alims, although they might act like alim. In Australia, we have these situations where there's actually people putting shaykhs on their name. They're not shaykhs, they're not ulama. But here in Pakistan, as far as I know, 99, as an example, as a country, 99.99% of the imams, it'd be very hard pressed to find an imam who's not an alim or a mufti, right? They're very fortunate in countries like that. But here, like people willy-nilly just sort of, so that's historically the imams were ulama. I'm not talking about superficial study, like a person who had probably like 6 to 10 years study under their belt of solid Sharia studies. That's one thing. So that's for the average person. For a talib al-ilm, for a serious seeker of Islamic sciences, knowledge of Islamic sciences, they should stay within the madrasa of a madhab. That's the second thing. And then for those who reach the pinnacles of knowledge, and after deep research, they form a view that it may be different from the view of the madhab, then this is something that is not censured in Islam. This is something come that a person's work and his work in trying to understand the haqq. But this is not open to the average student, the graduate out of madrasa, or coming out of Islamic university. This requires depth and fear of Allah subhanahu wa ta'ala and a long time in fiqh to form a view other than to go against your madhab. So this comes to the next topic, which is taqleed, which is translated here as imitating. So firstly is about the petitioner. We'll read this about the mustafti, the one seeking. So we talked about the mufti. Now we're talking about the one asking the question, seeking the fatwa. A condition of one petitioning the mufti, al-mustafti, is being from those who imitate scholars. So he follows the mufti in his verdict. If the individual is not among those qualified to imitate, by him being one of those qualified to make ijtihad, then he's not entitled to petition a mufti, just as the author says, it is not permissible for a scholar. And when he speaks about scholar, he's talking about a mujtahid, right? To imitate, since he possesses the wherewithal to perform ijtihad. So he's told us that who shouldn't do taqleed. Who shouldn't do taqleed is the one who's ahl for ijtihad. If you're not ahl for ijtihad, then you have to do taqleed. You have no choice. And this is, the ayat of the Quran itself tells you, if you don't know, ask the ones who know. So among the condition of one seeking a verdict is that he is among those capable of independent legal reasoning. So he conforms to legal experts in his verdict. It is not the scholar to conform to others. Legal conformity, al-taqleed, is to accept the opinion of someone without knowing its proof. All right? So imitating taqleed is accepting another's opinion without him mentioning its proof. Consequently, accepting the opinion of the Prophet ﷺ in the ruling that is mentioned is called imitation. Right? So this even applies today, but some say that imitation is to accept another's opinion while you do not know from where he took it. That is how he arrived at it. You don't know the behind the scenes process. And this mentions here as well. Among those who have said that legal conformity is to accept the opinion of someone without knowing on what basis he said it. If we say regarding the Nabi sallallahu alaihi wasallam spoke by analogy, like he did qiyas on a certain thing, it is permissible to refer to acceptance his statement as conformity. That when it comes to Rasulullah sallallahu alaihi wasallam, if we hold that the opinion of Rasulullah sallallahu alaihi wasallam gave ruling based on an analogical reasoning by exercising ijtihad, then it is permissible to call accepting his opinion imitation, taqleed. This is because it is possible that the opinion of the Prophet was based on ijtihad, right? So Rasulullah sallallahu alaihi wasallam could be mentioning a wahi that is being revealed to him at that moment, or that he's exercising ijtihad. If we hold the opinion that Rasulullah did not exercise ijtihad, but only he said things based on the revelation, right? As the ayat says, وَمَا يَنْتَقِ إِلَّا مَا وَحْيُ يُوحَى, nor does he speak out of passion. This is but a revelation, right? Then accepting his opinion is not considered imitation, taqleed, as it is revelation. It doesn't really, at the end of the day, whether you call it ittiba' or taqleed, there's no net effect. There's no, it's still a hujjah, regardless of which way Rasulullah sallallahu alaihi wasallam told us, whether it's through his personal ijtihad, whether it's a wahi at that time reveal, it makes no difference. And Imam Ibn Najjar al-Futuhi rahimahullah mentions that taqleed linguistically means to hang something in the neck, and in the terminology of the Usuli scholars, it is to take a madhab of another without knowing the proofs, right? And to go back to Rasulullah sallallahu alaihi wasallam and to a mufti and ijma'. As for going back to the Rasulullah sallallahu alaihi wasallam and to a mufti, an ijma', and I think it's not considered taqleed, even though it's called taqleed, right? And we're just coming to the last, second last. So when we talk about taqleed is criticized for the one who follows it when he is ahl for ijtihad, right? And the opposite is also true. Someone exercising ijtihad and he's not ahl for it. He's not qualified. He just graduated madrasa, let's say. He's done 7-8 years of study. Now he's going to become a mujtahid. Or just graduated the Bachelor of Sharia. Now he's going to become a mujtahid. Well, we've seen again and again what happens to those people. They generally, in terms of they lose cohesion and structure in their deen. They start to take, generally the taqwa is very less in this time. It's like removing the guardrails. I hope you understand what I'm saying. If you remove the guardrails that have been set there for more than 1,000 years, these guardrails that keep us on a straight and narrow of the Quran and Sunnah, therefore, it's like you have to be someone very high to jump the guardrails, Wallahu alam. As for the last section, which is about ijtihad, right? As for ijtihad, independent legal reasoning, al-ijtihad, it is to expand the sum of one's effort in achieving the objective. If the expert jurist has mastery over the mechanism of legal reasoning in secondary issues and his verdict is correct, he will have 2 rewards. If he reasons to a verdict and is mistaken, he'll have 1 reward. Ijtihad, personal reasoning, is expending. So what's ijtihad? Ijtihad is to expend energy, right, to make effort for something. And when it comes to ijtihad in the fiqhi term, it is to expend energy in reaching a hukm of sharia, practical hukm, through bitariqat istinbat, by deriving rulings. So what that takes a person out of taqleed, right? So expending all efforts in reaching the goal. That is the purpose of knowledge, so that the mujtahid achieves it. When a mujtahid exercises independent reasoning and branches issues and he has complete mastery of the tools for independent reasoning as preceded, and he hits the mark, he has 2 rewards for his personal reasoning and for hitting the mark. If he exercises independent reasoning and misses that, then he has 1 single reward. For his personal reasoning, the evidence is forthcoming. Some scholars held the opinion that every mujtahid is derived issues hits the mark, right? So every mujtahid that hits the mark. This is based upon the ruling of Allah deduced by him with respect to him and the one who imitates him being whatever his personal reason led to. However, the Hanbali say not every mujtahid hits the mark. Right? Others here, the book mentions that every mujtahid he hits the mark, but the Hanbali said not every. Only one of them can. There's 2 different views, 2 mujtahids, and one gives a different view from the other. One has to be right. Right? It doesn't change anything, because who's the only one that knows it's right? Allah subhanahu wa ta'ala. Right? Allah knows which one is more right, but both are rewarded. Right? It is not possible to hold the opinion that every mujtahid is en route theological beliefs hits the mark, since it would lead to declaring those who are misguided Christians because of their opinions regarding the Trinity, Zoroastrians because of their opinion of the dualistic nature of existence, light and dark, non-believers in their negation of monotheism, the Prophet ﷺ being delegated as a prophet and the resurrection of the afterlife, and atheists in their negation of the attributes of Allah, such as speech creating the actions of his devotees, and that he will be seen in the afterlife, and others is hitting the mark. Right? And remember that ijtihad is not in aqidah matters, right? It's only in fiqh. In short, yeah, so you cannot say that every mujtahid is correct, because then Christians and these different kuffar, they supposedly made ijtihad and they got nowhere, and you're also saying they're correct as well. through this. So there's an argument against that. The evidence for those who say that every mujtahid does not always hit the mark is the saying of Rasulullah, whoever exercises independent reasoning and hits the mark gets 2 rewards, and whoever exercises independent reasoning and misses gets 1 reward. The reason is that the Prophet declared some mujtahid missing the mark sometime and declaring them hitting in others. And the hadith, which is in Bukhari Muslim, that using Bukhari's wording, the judge exercises personal reasoning. If he passes judgments and hits the mark, he gets 2 rewards. If he passes judgment and is wrong, he has 1 reward. This is the end of just that regarding the topic. When, like, how would you know, or when would you know which mujtahid was correct? Like, they're both doing ijtihad, but how would you know? When would you know the ijtihad is correct? This is the last question for this class. When would it be known that the ijtihad is correct? Is anybody here? No. If you're doing taqleed, you're following a madhab, you're sticking to a madhab. Like, when would the mujtahid, since I mentioned earlier that only Allah knows, but when would we know? Or when would anybody know? Where do you get ajr? Where do you see ajr? Where do you receive your ajr? Come on, guys. Like, where do you receive your ajr? Do you receive it in this dunya? What's a place for ajr? No, the ajr is in akhirah. In dunya is barakah, rahmah, mercy. The effects of the ajr, the acceptance of amal is it, but ajr is in akhirah. Ajr is in Jannah, right? I mean, all of this that we're doing, inshallah, Allah accept, is to get to Jannah. Allah accept us, and then in Jannah. So I was reading in Hadi al-Arwah, if I remember correctly, Imam Ibn Qayyim rahimahullah writes this. He said that the mujtahid imams, right, they will have a majlis in Jannah, and they will know, then they will discuss fiqh masail there. They'll discuss waraqat and fiqh, and we can have a wise course there, inshallah, and we'll know which one is more right, whose usul of fiqh was more correct, whose ijtihad. So one of the enjoyments of this world is fiqh discussions, is fiqh munaqasha, like discussing muhadaras, like for the fuqaha, for the mujtahideen. This is it's such an enjoyable work and process, right? And he said the mujtahideen, they will meet in Jannah, wallahu alam, and they will discuss, because if they are accepted, they're getting 1 reward and the other one's getting 2 rewards. That means they're getting rewarded by Allah. But then one of them is right. And we will know which of our deeds are accepted in Jannah. That's an amazing thing to wrap our head around. Allah make us from the people of Jannah, make us into Jannah, die with Iman. But when those who enter the Jannah, that when they will know which of their a'mal in this life are accepted. Even on the day of judgment, when he's weighed in the scale, they'll know, oh, that istighfar that I did, that salat that I did, that wudu I did, that fast I did, that tawaf I did, that sadaqah I gave, that smile, every action that was accepted, that was done for the sake of Allah, and you know it's maqbool, the stamp of qabul is given, that is an amal that is rewarded by Allah, that amal, you will know which amal, including the ijtihad of the mujtahid mutlaq. The mujtahids will know their ijtihads. Whoever did the research, they knew which one is more correct. They'll know in Jannah. So this dunya is people are vying for this place and trying to get a chunk out of this, either in wealth or a position or name, or to be close to this person or that person. But we should have our sight on that place, Inshallah. May Allah subhanahu wa ta'ala give us understanding and tawfiq to practice what we say here. May Allah subhanahu wa ta'ala open fiqh and usul fiqh and all the Islamic sciences upon our hearts and give us tawfiq to practice, and that we benefit ourselves and the whole ummah, inshallah. and they will receive a full reward. And Allah subhanahu wa ta'ala reward Imam Juwayni, Imam Jalal Al-Mahalli, the brothers Shaykh Musa Furba, who translated it, and also Abu Amin Ilyas, who translated it as well, that we utilize their works. May Allah reward them. And the brothers, the team from Wise, I think there's two Khalids, and there's a few brothers there, Brother Yahya and so forth. May Allah reward them all for facilitating this, and the best of rewards. Ameen Ya Rabbil Alameen. Any questions, and we'll close, inshallah. If there's any question, by all means, type it now. Just one thing, that after, hopefully, when I come back next month, I will be doing a small poem, Imam Ibn Abi Dawood's Ha'iyah. I'm teaching it at the moment. Imam Safaridin's commentary. I should be finished by then as well, teaching that, the full commentary, 2 volumes. But the course we'll do, his 30-line poem, we'll probably do it over like a 10-week sort of a period as well, like 8 to 10 weeks classes covering the poem, inshallah. Yeah, that's right. Ijtihad is there, but in Aqidah, yeah, that's a big topic. Inshallah, in the Aqidah course, we can talk about that. Yeah, we all have to revise. This is a fiqh, usul of fiqh is a lifelong, just to, so put your mind at ease. Imam Ibn Abdul Bar spent 30 years on the Muwatta Imam Malik. He wrote several commentaries on it. I think when they say like Shaykh al-Islam Ibn Taymiyyah rahimahullah was a mujtahid, definitely he was a unique scholar. The level of what's considered a mujtahid from the Hanbali perspective, right? That a scholar that who is mutabahir, he's very well versed, erudite scholar, who knows the ins and outs of the nusus and so forth. But his family. I mean, just put it into perspective, he's coming 500 years Imam Ahmad. He's coming a century later after Imam Ibn Qudama Maqdisi, as an example, right? So you got to put a person, Anzilu Nasa Manazilahum. He's not great. Shaykh al-Islam Ibn Taymiyyah is not greater than in fiqh than Imam Ahmad ibn Hanbal rahmatullahi, or Ibn Qudama al-Maqdisi, or Shaykh Abdul Qadir Jilani, and on and on and on. So there are greats that are before him. There are other greats, but he's a unique figure in the Hanbali mazhab. He's Shaykh al-Islam. He's a unique figure. He has a forceful argument, whether it be aqidah or fiqh and so forth. He has a unique mind. Somewhere I was reading, he didn't see like anybody like himself, and nobody saw the likes of him in his generation. But he had some anomalous position. But you better read all. In terms of forming a view about Shaykh Islam Taymiyyah, rahimahullah, I'll finish off with this. My father, rahimahullah, Shaykh Said, he said to me like about him or Imam Suyuti or any of these big imams, you better read all their stuff before you form an opinion for or against him on an issue, right? These imams of the past, and we respect them and so forth, right? They make mistakes and so forth, but you better know their stuff. You better know about their life firstly, like what type of taqwa they had before we start to critique them. And you also should read all their works, right? Like Majmu' Fatwa, read all that from beginning to end. And I can tell you a lot of the people who use his name today have not read it, right? Especially stuff on tasawwuf and ruhaniyat and so forth in volume 10 and 11. Most people that will go over the head of most people. When he starts speaking about fana and so forth and spiritual terms, most people don't know. So this is the thing, that it's he wasn't a mujtahid mutlaq. Yeah, he was a mujtahid for sure. He was a unique scholar and he did ijtihad. But we got to put people according to their positions, and he doesn't take the place of the 4 great imams, example, or the early imams, or the tabi'in or tabi'in, and on and on and on. So he had position, and his positions, I mean, Ibn Rajab al-Hanbali and others, they have this is a big topic. We'll leave it for the other course, inshallah. It's not aqidah, of course. But once you start these discussions, we'll go on and on. But he's been processed by the later Hanbalis. I'll finish off with this. He's been processed, and there are people like Ibn Rajab and others who have processed him, because they're students. They processed him, and Wallahu alam. Some of his views have been upheld and defended, and other views of his, they've been shown to that he's made. My father's teacher, Mawlana Anwar Shah Kashmiri, rahmatullahi alayhi, he has some choice words. Basically, like he was not like to treat him. There's extremes regarding him. Some people treat him as the agent of Yahud. Others treat him as the Mujtahid Mutlaq. The truth is somewhere in the middle. May Allah give us understanding, tawfiq. Barakallah feekum. Remember in your du'as, inshallah. Hopefully I'll see you again in another course. Assalamu alaikum wa rahmatullahi wa barakatuh. You're asking questions and I'm about to leave, but the Ha'iyya, I'll use Imam Safarini, but it was just notes because these are slides. It's only 30 lines. I'll try to do like 3 lines a week, like in a summary. Safarini's, Imam Safarini rahmullah's commentary is too long. Sheikh Badr, where's Abdul Razak Badr? He did a commentary on it from Masjid Nabawi. He teaches in it. It's nice. Yeah, it does push the Salafi point on certain things and the Shaykh al-Islam's point on certain things. But Imam Safarini is quite, every time, if you read Imam Safarini's commentary, wherever the Muhaqqiq, I can't remember who was some Salafi scholar, wherever a point comes where now he's got to defend or push the against Imam Safarini, there's like 3 pages of footnotes extra, which is now he's got to defend, he's got to like push his point. But anyway, that's Shaykh Hassan's Shati's ones, his Mukhtasar, I've taught that as well, alhamdulillah bi tawfiq to alim students, 50 students. This year I decided that I want to read through the whole work, the complete, but it's very long, and Shaykh al-Islam Ibn Taymiyyah rahimahullah makes massive, we're reading through it now. We finished the first volume a few days ago and now we're in the second volume. Sort of like we skipped the first 70 pages about Sahaba radiallahu anhu because that's sort of straightforward, very like we went through it very quickly. I think the matter of Qadr, I think there's the first masala. We have to Muawiyah radiallahu anhu because that's where there's contention with groups. So where the students will benefit from, but the students are required to read it. So we're going through the whole work, inshallah, Allah give us tawfiq. But that's a good reference as opposed to maybe a darsi book. The Mukhtasar is much better as a darsi book that boils it down to a good class book. But even that's a bit too long for our purposes for this course. But I'll probably utilize it, inshallah. All right. There's no more questions, all right? Yeah, exactly. Like Mughni. Inshallah. All right. Assalamu alaikum wa rahmatullahi wa barakatuh. Jazakallah khair.